Hello everyone, welcome to your Lordship's revised through MCQ series. So today I am going to discuss the MCQ of Indian Evidence Act, or you can say the Bharatiya Sakshya Adhiniyam. So the very first question of this, which is generally asked in the examination, is law of evidence is. So this has been asked in Uttarakhand, in UP Judiciary also. Law of evidence is, and the options are lex talionis, lex fori, lex loci salonis, and lex situs. These are the options which are given. That law of evidence is. Let's see the answers. Answer B is correct, that is lex fori. Now what is the explanation of it? The law of evidence is considered lex fori, meaning it is governed by the law of the forum or the country where the legal proceedings are conducted. In other words, matter relating to evidence are regulated by the procedural law of the place where the case is being tried. So this is lex fori, means law of the land. That is why that option is correct. See the second question. Second question, which is generally asked in examination in Uttarakhand 2022, this was asked, which of the following terms has not been defined by Indian Evidence Act under section 3? And the options are court, document, evidence, or confession. Now let's see the answer. Answer is D, that is confession. Confession has not been defined under the Indian Evidence Act under section 3, because under section 3 the court, document, and evidence has been defined, but not the confession. Let's see the next question. Question 3 is, in which of the following instances does evidence means a fact which serves as the foundation for an inference? This has again been asked in Uttarakhand Judiciary. The options are direct evidence, circumstantial evidence, both A and B, none of the above. So again, in which of the following instances does evidence means a fact which serves as the foundation of an inference? Let's see the answer. It is B, circumstantial evidence. Circumstantial evidences. So of course, as a foundation of inference, where anything could be inferred, not directly there, but inferred, that is circumstantial evidences. See the explanation. Circumstantial evidence is indirect in nature. It does not directly establish a fact in issue, but instead leads to a logical inferences suggesting the existence of that fact. It relies on the drawing of reasonable conclusions from surrounding facts to support a claim. The next question is, the Panchsheel golden principles of circumstantial evidence has been laid down in which of the following case? This has been asked in Uttarakhand Judiciary 2023 paper, and this is a very important question which is generally asked in all judicial services examination. The options are Padala Veera Reddy versus State of Andhra Pradesh, Chhattar Singh versus State of Haryana, Sharad Vidhichand Saroda versus State of Maharashtra, State of Punjab versus Gurmeet Singh. Let's see the answer. The answer is Sharad Vidhichand Sarada versus State of Maharashtra. The Panchsheel golden principle of circumstantial evidence. Why it is called Panchsheel? Because 5 principles were laid down. Let's see the explanation. These were the principles that were laid down in 1984 case. These are the 5 principles, circumstances from which conclusion of guilt is to be drawn, should be and not merely may be. In fact, the established should be consistent. So these are the 5 principles basically which have been laid down in this case. So you need to memorize the name of the case. Next question is, select the incorrect statement using the code given below. The Indian Evidence Act does not apply to arbitration proceeding. The Indian Evidence Act does not apply to proceedings before a commissioner appointed by the court for recording evidence. The Indian Evidence Act applies to affidavits presented to court. The Indian Evidence Act applies to judicial proceedings held before all kinds of military courts. Again, this has been asked in UP Judiciary examination. Let's see the options. 2 and 3 are incorrect, 2, 3 and 4 are incorrect, 1 and 3 are incorrect, none of the above is incorrect. Let's see the answer. It is 2, 3 and 4 are incorrect. So only one is correct. The Indian Evidence Act does not apply to arbitration proceedings. And the question was which one is incorrect. So 2, 3 and 4, all the three are incorrect. And this is the explanation which is given in extent section 1 of Indian Evidence Act, that says it extends to whole of India and applies to all judicial proceedings or before any court, including court martial other than the court martial convened under Army Act, Navy Discipline Act and Indian Navy Act or the Air Force Act, but not to affidavits presented to any court or officer, not to proceedings before an arbitrator. Next question is, which of the following means a fact to be proved? This has again been asked in Uttarakhand Judiciary. Options are quid probandum, modus probandi, both A and B, none of the above. So let's see the answer. The answer is quid probandum, that is A option. Now what is quid probandum? The law of evidence addresses two key aspects: quid probandum, meaning the fact that needs to be proved, and modus probandi, which refers to the method or manner of proving that fact. So this was related to the quid probandum. And the next question is, not proved means, what do you understand by the term not proved? And the options are, it is not proved, it has been disproved, it is neither proved nor disproved, it is denied. The correct option is C, it is neither proved nor disproved. And see the explanation. Not proved under section 3 of Indian Evidence Act, it is given that a fact is said not proved when it is neither proved nor disproved. Under the Bharatiya Sakshya Niyam, now this has been renumbered as section 2(1)(I). The next question is, conclusive proof means, it has been asked in 2014 West Bengal Judiciary. Options are A, where court presumes a fact, those evidence which are necessary to reach at judgment. Court grants permission to prove a conclusive proof. When one fact is declared by the Indian Evidence Act to be conclusive proof of another court, shall on proof of one fact regard the other fact as proved and shall not allow evidence to be given for the purpose of disproving it. Let's see the answer. Answer is D, when one fact is declared by the Indian Evidence Act to be conclusive proof of another, the court shall on proof of one fact regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. So conclusive proof is given under section 4 of Indian Evidence Act. Now it has been renumbered as section 2(1)(b) in BSA. Next question is, the court under the law of evidence presume that first, the accused is innocent, the accused is guilty, the general exception in the Indian Penal Code was absent, the general exception in the Indian Penal Code was present. Options are 1 and 2 are correct, 2 and 3 are correct, 3 and 4 are correct, 1 and 3 are correct. Let's see the answer. The answer is 1 and 3 are correct. The court under the law of evidence presumed that the accused is innocent, and 4, the general exception in the Indian Penal Code was, the general exception 3 is, the general exception in the Indian Penal Code was absent. Now what is the explanation? The accused is presumed to be innocent until proven guilty. As per section 105 of Indian Evidence Act, the court does not presume the existence of general exceptions. The burden of proving such exception lies on the accused. When one fact is declared conclusive proof of another, which following is untrue? It has been asked in Himachal Pradesh Judiciary 2023. It is a mandatory presumption, it is an irrebuttable presumption. The court may at its discretion allow evidence to refute the presumption. The court shall not allow evidence to be disproved the presumption. Let's see the answer. The court may at its discretion allow evidence to refute the presumption. Now what is the justification? In the case of conclusive or irrebuttable presumption, the law mandates that once the fact is proved, another fact must be accepted as true without allowing any contrary evidence. Hence, the court has no discretion to permit rebuttal. Next question. A is tried for murder of B by intentionally beating him with a club, causing his death. Which of the following facts are in issue? This has been asked in Chhattisgarh Judicial Exam. A is beating B with club. A is causing B's death by such beating. A is intention to cause B's death. All of the above. Let's see the answer. It's all of the above because all the facts are in issue. Now, what is fact in issue? That is given as per the illustration under section 3 of the Indian Evidence Act. All the mentioned facts are fact in issue because they are essential to determine whether offense of murder was committed. They relate to A's acts, its consequences and his intention, each being crucial to establish guilt or innocence. Next question is, Indian Evidence Act consists of, again this has been asked in Uttarakhand Judiciary, Chhattisgarh Judiciary Exam, 11 chapters, 167 sections, 11 chapters, 2 schedules, 11 chapters, 197 sections, 11 chapters, 3 schedules. Let's see the answer. 11 chapters and 167 sections. So these are very basic questions which you should not, a student should not miss or give the wrong answer, because these will give you 2 marks just by recollecting the section number, total number of sections and the chapters. Now see, question number 13. In the law of evidence, fact means and includes anything perceived by the senses, a state of thing capable of being perceived by senses, mental condition of a person of which a person is conscious, all of the above. These are the 4 options. Anything perceived by the senses, a state of thing capable of being perceived by the senses, mental condition of a person of which a person is conscious, all of the above. The answer is all of the above because Section 3 of Indian Evidence Act defines fact. That means anything, state of thing, relation of thing capable of being perceived by senses, any mental condition of which a person is conscious. Now the same has been renumbered as Section 2(1)(f) of Bharatiya Sakshya Adhiniyam. The next question is, law of evidence is, again it has been asked in Bihar Judiciary, a substantive law, an adjective law, both A and B, neither A or B. Answer is, it is an adjective law. Why? The law of evidence is considered part of procedural and adjective law, and it governs the manner in which facts are presented and proved in a court of law, rather than conferring substantive rights. In Datta Ziva Naik Desai versus State in 1967, it was clarified that since the law of evidence is procedural, it may be applied retrospectively also. That is why it is adjective. So it is asked, substantive hai, procedural hai, adjective hai. The next question is, as per Indian Evidence Act, court includes, in Gujarat Judiciary it was asked in 2023, and the options are all judges and magistrate, all persons legally authorized to take evidence, arbitrators, both A and B. Let's see the answer. Both A and B. So all judges and magistrate and all persons legally authorized to take evidences. So this is given again in section 3 of Indian Evidence Act, where the court has been defined as court includes judges and magistrates and all persons except arbitrators legally authorized to take evidence. Now under the BSA, the same has been renumbered as section 2(1)(a). Now there are proposed questions of BSA which might be asked in your upcoming examinations. Under Bharatiya Sakshya Adhiniyam 2023, the term document is defined under, and the section number is 2(1)(c), 2(1)(d), 2(1)(e), 2(1)(f). Now see the answer, it is section 2(1)(d) where the term document has been defined, and it is given in 2(1)(d). Document means any matter expressed, described or otherwise recorded upon. Next question. BSA is an options. Act to consolidate and to provide for general rules, principles of evidence for fair trial. Act to consolidate, amend and provide for general rules and principles of evidence for fair trial. Act to consolidate, amend, define and to provide for general rules and principles of evidence for fair trial. Act to consolidate, amend and define the general rules and principles of evidence for fair trial, which is given in the preamble part itself, in the introductory part itself. So the correct answer is A, Act to consolidate and provide for general rules and principles of evidence for fair trial. So as I told you, it is given in the preamble of BSA, Act to consolidate and to provide for general rules and principles of evidence for fair trial. It is normally asked in your examination that what is the preamble, what is the purpose of this law. The next question is, in BSA there are total number of sections. How many number of sections are there? 167, 168, 169, 170. See, you just memorize the number of sections and you will get 2 marks. Correct answer is section 170. It is given in the new act in Bharatiya Sakshar Niyam 2023. It comprises 12 chapters and 170 sections. Next question is, which section of BSA permits the presentation of evidence on relevant and directly disputed facts? Which section of BSA permits the presentation of evidence on relevant and direct disputed facts? Section 2, 4, 3, 5. Answer is section 3. See the explanation. Section 3 provides evidence may be given of facts in issue and a relevant fact. So the next question is, what is the official date of implementation for Bharatiya Sakshar Niyam 2023? Is it 15th March 2023, 1st July 2023, 1st July 2024 or 1st February 2024? And the answer is 1st July 2024. Because it has been, the Bharatiya Sakshar Niyam was formally enacted on December 25th, 2023 and the central government notified that it would come into force on 1st July 2024. So such kind of questions are asked that on which date it was implemented or in force. So for more such questions and queries, kindly visit our website yourlordship.in and kindly subscribe our channel, Your Lordships. Thank you so much.